Did the Supreme Court of the United States really just determine that the eastern half of Oklahoma belongs to the Creek Nation Indian Reservation? Kind of. They did. But what does that actually mean and how does that play out? Well, that's a little bit more complicated. Let's talk about it. Hey, what's up, guys? Welcome to Law Explaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we're talking about the recent decision, McGirt versus Oklahoma, which just came down on July 9th of 2020, which was yesterday as of the recording of this video. And the news stories that swirled around it basically stating that the Supreme Court just ruled that half of Oklahoma belongs to the Creek Nation Indian Reservation, specifically the eastern half. And a lot of people are confused about what that means. Does that mean that all of these people are living on reservation land? Does that change their day-to-day lives? Does it change the ownership? Does it subject them to tribal law? And the answer is not really. Not really. On a lot of that stuff. What this decision actually focused on was what is determined Indian land under the Major Crimes Act, and focusing down the decision to what it means to be Indian land under the Major Crimes Act is the important part of this discussion and the key distinction to all of those other questions. So what is the Major Crimes Act, you may ask? The Major Crimes Act was passed in the late 1800s, and it had to do with how major crimes were adjudicated amongst Indians on Indian land, because Indians on Indian land are subject to the laws of the tribe. They're able to establish their own tribal laws as basically miniature sovereign nations, right? Now, that doesn't mean they're exempt from all other laws, all state and federal laws. There's a lot of statutes that have defined over the course of years what actual laws they're subject to and what laws they're not subject to, so long as they occupy and own the land as a reservation. So these are the main things the court was determining, is that basically under the statutes as they have been rolled out over the years, the federal Congress has not determined that the Creek Nation land in eastern Oklahoma to be fully United States property. It is still part of the Creek Nation Indian Reservation, and therefore some of the distinctions do still apply. And again, it's important to limit this decision to the Major Crimes Act, because that is what is done in the actual opinion of the court. This is limited to the Major Crimes Act. So the Major Crimes Act determines which major crimes very specifically are tried by the federal courts. So when I mentioned that you're able to establish their own tribal laws and stuff like that, there's some crimes which the federal government says, yeah, you can establish your own system of laws and your own enforcement, your own courts, that's fine. But these ones right here, we're going to go ahead and still say we have jurisdiction on those. And those offenses are as follows. I'll just read them to you. Here is Section A. It's 18 U.S. Code Section 1153, subsection A, offenses committed within Indian country. Any Indian who commits against the person or property of another Indian or other person any of the following offenses, namely murder, manslaughter, kidnapping, maiming, a felony under Chapter 109A, incest, a felony assault under Section 113, an assault against an individual who has not attained the age of 16 years, felony child abuse or neglect, arson, burglary, robbery, and felony under Section 661 in this title within the Indian country shall be subject to the same law and penalties as all other persons committing any of the above offenses within the exclusive jurisdiction of the United States. Okay, so that means that the tribes cannot just carve out exceptions that would allow them to murder people. it's in the federal government's interest and in the state of Oklahoma's interest that that a Indian, to quote the law, on Indian land murdering someone should probably be prosecuted in the same way that a federal murder in any other area would be taken care of. So, you know, traffic violations, misdemeanors, even gross misdemeanors, drug charges, stuff like that, that can be handled by tribal land or by tribal courts. But once you get up into the crimes that really genuinely affect the rights of other people, the safety of other people, and the lives of other people, to the point where they're deemed federal felonies, you don't get to, at that point, exempt anybody from the consequences of their actions. Now, why is this coming up in McGirt versus Oklahoma? Some brief backstory on that, and I'm not going to get into it too much because YouTube will not want me to describe this. But basically, a 70-plus-year-old man assaulted a minor child, a very young minor child, and was found in the state of Oklahoma by state courts to have committed that act and was sentenced to basically 1,000 years in state prison. So that's where this argument comes from. He says that he should be entitled to a new trial under the Major Crimes Act. And the Supreme Court agrees. And should they have agreed? Yeah, probably. They probably should have. He's an Indian for purposes of the statute on Indian land. That means that he is subject to the Major Crimes Act. Now, does that mean he gets to walk? In theory, yes and no, which is terrible. And this, of course, is a horrific crime and should be prosecuted to the maximum extent. And if the guy is guilty, you know, he should suffer the penalty that he is due. That being said, he doesn't get to walk per se. The federal government would just have to make those charges. Now, what's the risk of this sort of decision and what's the fallout from it? The risk and the tangible fallout from it is there are approximately 1,700, according to the research that the court has available, approximately 1,700 similarly situated inmates in Oklahoma State Prison right now. That means that there are 1,700 Native Americans who were prosecuted by state courts for crimes committed on Native land. That's a violation of the Major Crimes Act. It's a violation of the federal treaties which have established the Creek Nation, and that's what the Supreme Court is clarifying here. Now, all of those people do not immediately get released from jail. They would have to make their petitions. They would be able to bring new appeals court cases. They probably will be doing that in droves, as they should, but they will have to get their decisions overturned. They'll have to prove that they were Native, sufficiently categorized as Indians for the purposes of the statute, that they were sufficiently on Indian land under the understandings of the treaties at the time that they were convicted of these crimes, and that the state court didn't have jurisdiction. That is an argument that they get to make. And this court, you know, will this Supreme Court decision will guide those cases, but they still have to make those arguments. And some people won't do it. Other people will. They'll prevail or fail on their own merits. And then at the end of the day, they may be charged with federal crimes by federal prosecutors, depending on what the crime is, depending on the status of the victims, depending on how long ago the crime was, depending on access to evidence. All of those different factors will come in and determine what everybody in these cases wants to do. I mean, for some people, it might be nice to have the record of their criminal act removed, saying, you know, dismissed and saying that it was invalid. And once they do that, they may be entitled to sue the state for wrongful prosecutions. But those cases get difficult and expensive and all of that stuff. What can probably be assumed is that the state and the tribe will work together. They've already made a joint statement about working together going forward, but that they will work out what happens with these criminals who are prosecuted under state law. Maybe they'll get re-prosecuted by the tribe if they don't fall under the Major Crimes Act, maybe not. And that will be a big determination that they'll have to make going forward to make a judicially efficient process for determining what should happen with all of these locked up people. It's not a simple matter. The Supreme Court treats it as a relatively simple matter, basically saying, well, they'll work it out. And they will, because this type of stuff happens with some regularity in regards to major criminal appeals hitting the Supreme Court, and then the Supreme Court handing a victory to the appellant. And once that happens, you know, it changes the criminal landscape because the Supreme Court says, no, it was always this way, and the courts up until now have been wrong. It's a big mess, but they deal with it with some sort of regularity. But to summarize and reiterate, yes, the Supreme Court ruled that under the Major Crimes Act, and that is the important distinction, roughly the eastern half of Oklahoma remains Creek Nation reservation, and therefore major crimes committed by Native Americans on the reservation must be prosecuted by either the tribe or the federal government who has jurisdiction to do so. And as far as major crimes go, the ones that are specifically listed, it is the exclusive jurisdiction of the United States, which means that that would be the federal courts. So how does that affect non-natives? If you are an Oklahoman and non-native, but you happen to reside within that area, it doesn't affect you. You're still subject to the state of Oklahoma's laws as they apply there, and you get the same benefits of living in reservation land that anybody else would and that you would already enjoy, if you do enjoy any. I'm not familiar with what the benefit or detriment would be to living on reservation land in eastern Oklahoma right now. However, any of those benefits that you would have had, you still have as a non-native person. This is really a pretty limited decision, limited specifically to natives on native land in Oklahoma committing crimes. That's it. So don't always listen to those sensationalist headlines. They tend to overstate what has happened in a Supreme Court case when you really narrow down the issue. And guys, it's to be understood, it's only basically in the first line of the text that the court explains that it's narrowed down to this specific subject. Here, let me read from the syllabus. Held for Major Crimes Act purposes, land reserved for the Creek Nation since the 19th century remains Indian country. That's the first heading in the syllabus under holdings. So it's on the first page. It's a paragraph down, and it must have been hard to find when they were coming up with these headlines, but that's the reality. All right, guys, I hope you liked this video. I hope you found it educational and informative. And if you did, please like it, share it, throw it around. Let people know that this is not this weird situation where half of Oklahoma is no longer Oklahoma or some nonsense like that. It still very much is Oklahoma under almost, for the overwhelming majority of people, it will be the exact same and their day-to-day lives will not change. That's the reality of this decision, and the reality of many Supreme Court decisions, actually, when you get down to it. But that's a topic for another day. I hope you have a great one. Peace. Peace.